Good. Hello. Hope everybody's well. Not legal advice, and it really is not legal advice. Like, subscribe, share, all those things. Like, subscribe, share, comment. You will note that I always look at everybody's comments, and sometimes I'll even respond. But you'll know I looked at it because I will indicate that I've looked at it. So please do so. If you have questions, please throw those at me. I'm happy to deal with those also. And share and let your animals watch in particular. So I'm going to talk about a few things. I'm going to talk a little bit about the steamroller pre-litigation, MMTLP, MMAT, Sorrento Therapeutics, my arbitration, and Alpine. And we'll see if we can do that in all in like 34 seconds. Just kidding, of course. Before we get started, of course, I had some questions I wanted to throw out and see if you had any ideas. Why did the stockbroker quit his job to become a baker? He overheard advice that said, buy dough, sell pie. Why should you be careful about what you say around egg whites? Because everyone knows they can't take a yolk. And last but not least, and some people might have to cover their ears for this one, but last but not least, why did the new egg feel so good? Because he just got laid, obviously. All right. So, first of all, I wanted to deal with the steamroller pre-litigation petition. And if you recall, some time ago, a couple months ago, Mr. Basile filed a petition involving the December 2022 MMTLP shenanigans, trying to locate who were the defendants that should be named in that action. And if you recall, in New York, they have a statute that lets you, before you actually file the lawsuit, it lets you ascertain the names of the defendants if you can't locate them. And, sometimes it's hard to figure it out. So that first petition was filed. It was denied. It's up on appeal. The second petition was filed. It relates to the time frame October 2021 when MMTLP was allowed to trade. And it only concerns the activities and shenanigans that permitted MMTLP to trade unlawfully and permissibly fraudulently. So it's very narrow. And that's this one. So the petition has been filed. What was filed last week or this week was an opposition. And the opposition, I think it's the OTCC filed the opposition. The prior one was filed by FINRA, I believe. I think it was FINRA, not the SEC. But what the basic position that was taken in the opposition, I read through it and I read through the affidavits, at least skimmed enough to kind of figure it out. And by the way, I can read pretty fast, legal documents pretty fast, and kind of get to the heart of it. So, in essence, what they said, this was redundant of the prior petition. In other words, this was just kind of a substitute, identical to the prior petition, and the prior petition was denied, so this one should be denied. And the issue beyond that was since it was a fraud claim, there has to be specific pleading of fraud, and this didn't plead fraud specifically. I didn't think it was like a super job on that brief. I didn't think it was terrible, but I didn't think it was super compelling because it relied too much on the fact that this was the same as the prior, and I don't think it is the same. I think this argument's much more compelling. So I read the opposition. Again, their position is it's pretty much the same thing as the first one, so deny the petition. I will wait to see what Mark's reply. So in other words, the way it goes is you file a petition, then the other side will file an opposition, and then Mark has a chance to reply. So he will have a chance to reply, or somebody in his office will reply. They will show why they've stated a meritorious cause of action and why this is dissimilar from the first petition and why the court should grant access to the names of those scumbags who unlawfully traded MMTLP in October 2021, which set up this entire nonsense, which also might lead to interesting places if that information is disclosed. And under that statute in New York, which we don't have in California, to be able to get that information, again, pre-litigation identification of the defendants, you still have to show that you have a meritorious cause of action and that the documents are material and are needed to establish that cause of action, which really is the defendants in this case, or it could be damages, I guess. So that's where that stands. So petition, opposition, we'll wait for a reply, then there'll be a hearing. As to the prior petition, there's an appeal pending, and we will wait to see, and we'll comment on briefs as they're filed, and we'll see what happens as to the outcome. So that's the Steamroller pre-litigation petition regarding MMTLP, MMAT, I guess also. Second, Sorrento Therapeutics, and Mr. JR and I, several months ago, I think it was May or June, brought up Sorrento Therapeutics, because that was a case in Texas bankruptcy court where in the bankruptcy, they filed Chapter 11. Chapter 11 is a reorganization. So a company can file for reorganization, can reorganize its debts and et cetera, and then come out as a business and in a better financial position. Separate from Chapter 11, there's Chapter 7. Chapter 7 is just going out of business. So we're not talking about Chapter 7 going out of business. We're just talking about reorganization here. And Sorrento Therapeutics was a bio drug company and it has I guess it has a subsidiary called Skylex or Silex. You might have heard about that. But the point was, this company was heavily shorted. And within the bankruptcy, there was a complaint filed against brokers claiming that they had naked shorted Sorrento Therapeutics. And in that bankruptcy case, the judge ordered that the brokers disclose their share counts. And because of the share counts disclosed, the judge determined that there were naked counterfeit shorts. So that's in the order. And after that, the shorts were permitted confidentially to cover their positions. And the way the valuation was done, there was a committee formed, but was led by the company, not the shorts, to figure out a value. And that was to the extent that those brokers took advantage of that. They paid out money to close out their positions. So in that case, because it was in a Chapter 11, in that bankruptcy, the court was able to establish actual naked short positions on the record, and they required closing of those positions. So it's just another way of proceeding as opposed to reverse splits and all that nonsense. If you have a company, and I'm referring to, like, for example, I'll use both, Mullen, MMAT, both just struggling beyond belief. Both, Mullen's been reverse split and maybe again, Mullen, and MMAT is, we don't know what's going on with board of directors, management. Seems like shenanigans there too. But the companies are near financial insolvency. So as opposed to reverse split and jerking around, to me, the best solution sounds if you could follow the Sorrento Therapeutics game plan, file a Chapter 11, go into bankruptcy court, get the bankruptcy court to force the brokers to disclose their counterfeit positions and have them close, have the company be refinanced in essence by that closure, have everybody's position cleared, and close out the short positions. So this is separate and apart from any other strategy, but it worked in Sorrento Therapeutics, at least worked partially. It's a strategy that I think companies that are certainly on the verge of bankruptcy should obviously pursue, at least pursue to see if it fits, if it works for them. But again, that's Sorrento Therapeutics, Chapter 11, again, not going out of business, just kind of reorganizing the business, and the ability to expose the shorts and force them to cover, kind of what we want. So any small company CEOs out there, you should well, if you want to speak about it, contact a really good bankruptcy lawyer, or I can refer you information where you could follow it yourself. I could send you the Sorrento Therapeutic stuff, and you could contact the people that were involved there. I'm not a bankruptcy lawyer, so I certainly wouldn't know. But again, seemed to be like a certain strategy that would be really helpful for us. 3, my arbitration. As I indicated, I filed a recusal motion. That means a recusal motion is where I'm asking the arbiters to step down because of various reasons. I described the reasons: incompetence, bias, just lack of interest, etc. And it concerned primarily that there was a U3 halt, which required extraordinary circumstances. I sought discovery because special discovery permits discovery where there's exceptional circumstances. I said FINRA had already decided, and in reviewing my motions and requests for depositions, the sole reasoning offered by this brilliant panel was no reasoning, and no hearings were provided also. And the order itself kind of suggested otherwise. So there's no way possible a non-lawyer could understand what I filed, honestly, without oral argument. And I just was offended by the lack of respect and work that these gentlemen put in to this point in time. It's not like this is free. I actually have to pay for this arbitration. So if I pay for it, I expect competence, not nonsense. So as a result, that's why I filed the recusal motions. I'm going to be filing something with the federal court to advise them what's going on, and we will see where it goes. But of course, I will advise you of all this as it goes on. I have not yet gotten a response to my recusal motion, my motion to get rid of the arbiters. I've not got a response. As soon as I get a response, I'll summarize that too. So that's all entertaining. I was kind of pissed off Sunday because of the having to write the recusal motion, and really I thought it was offensive, just the way those gentlemen handled their duties as arbiters. And I'm not going to let them get away without letting them know how I feel about it. And I think all my accusations were accurate. So last but not least is Alpine. And Big JR, not Mr. JR, was so nice enough to have sent me an order this morning in a case involving the SEC versus GPB Capital et al. So et al, by the way, when you hear that used in legal terms, that means, and there's a bunch of additional names after that. So it's GPB Capital et al means there might be 6 or 7 additional names. And in that particular matter, which was a 2021 matter, the SEC got a receiver appointed to take over the business of these defendant jokers. And I have been, I don't know, since the last 6 months, I would say, I've been clamoring for the SEC FINRA to go into federal court and get a receiver appointed to take over Alpine in light of their gross misconduct, much of it admitted. And now we see that the SEC has done it previously. So what's the excuse not for doing it in the Alpine situation? What is going on? I mean, is someone being paid off? Is that the bottom line? Is someone, the SEC or FINRA, being compensated for not doing the full extent of going after Alpine that is appropriate? So again, I was clamoring about FINRA going into federal court in light of all the misconduct to take over Alpine's business. Here we know it can be done and has been done in the past. So do it now. Anyway, hope that was of some interest and clarity. And again, if you have questions or it's confusing or something, feel free to comment and let me know, and I'll try to respond. Everyone be well, take care, have a great day. And now I am signing